the government to do is to take action, or to appear to take action in a context where the government is not intervening in other areas that really give us more security as people living on this land. So things like education, healthcare, and other things that allow us to move forward. So purge, disempower, divert, distract, appear to act. Only time will tell if this well-rehearsed and mastered formula used more recently by the Harper government will curry enough favor from voters when the writ drops for the 2015 federal election. In the meantime, people like Deepan are getting hurt, and our common humanity is under attack as well as a result. So unfortunately I have to run to an exam for a class that I'm teaching in a couple of minutes, but I really appreciate the opportunity to kind of think about what the implications of this are, and to support Deepan to resist state repression. So thank you for your time.
Thank you very much, Justin, and I wish you the best of luck with the exams. Next on our panel, we have a professor of criminology at the University of Ottawa. Her name is Claire Delisle, and she'll be speaking on Deepan's situation and the broader narratives that it has for Canada. Claire?
Thank you. Thank you very much for inviting me, and I'd like to thank the students in my class who organized this. And I'd like to salute my fellow speakers as well, and to Deepan also. Hello. Today I want to talk about something a little bit different. It's about a research project that I am trying to get organized with some people from OPIRG, and also Josh here, our MC for today. And it's about statelessness, it's about mapping statelessness, it's about thinking about what this does in a country like Canada to have this problem or to have this situation. So it forces us to think in terms of new forms of punishment, forms of double punishment, the intersection between citizenship and statelessness, and all the harm that can come from that. And so what we hope to be able to do is to get together with organizations that are resisting this type of behavior, government behavior, people like No One Is Illegal, Amnesty International, and other groups, as well as some like-minded scholars who would like to invest some energy in thinking about statelessness in a bit more deep fashion. The United Nations thinks that Canada has no stateless people, if you can imagine, and so we'd like to sort of contradict that little statistic for one thing by mapping statelessness here in Canada, and by getting together with the people who are most directly affected by it, the stateless themselves, so that they might be able to have a voice to explain actually what the direct consequences on their life situation that this brings forth. In terms of the theoretical grounding, if I could just mention it very briefly, it comes from, you know, an Agamben concept of the ban, and how we seek, or our government is seeking to further ostracize and get rid of, deport, extradite, ban, kill a whole range of citizens who for some reason we don't know how to integrate into the political community. And so the double punishment also that comes from the fact that in Deepan's case, it is related to something that has to do with having committed an offense. And so now we are at the point where we can envisage a situation where people who do not fit the mold will be further banished from our communities. And so we're hoping that we're going to be able to have a big roundtable discussion with a lot of people who have a vested interest in this. and be able to move forth so that we can actually create a network for people who have those kinds of concerns to be able to come together and make some headway in terms of the kind of knowledge that we can share and strategies that we can put in place to counter this type of government action and government legislation. Thank you.
Thank you very much, Claire. And yeah, as she alluded to there, we are thinking about a project on statelessness since the United Nations claims there are 0 stateless people. Next on our panel today, we have Yavar Hameed, who is a civil liberties and human rights attorney who currently represents Mr. Deepan Budlakoti. I'd like to invite Yavar up here right now to speak on the case and what it means for the future of Deepan's life here in Canada.
Thanks very much, Josh. I'd like to acknowledge where we sit today on unceded Algonquin territory, and thank Deepan for really being the motivator behind not only the advocacy for his case, but a broader public campaign. And this really draws into question the arbitrariness by which Canada continues to regulate its borders and define who belongs and who does not belong. And in this case, a person who has lived his entire life in Canada knows no other community, no other country, no other social context than Canada is being told that not only is he not Canadian, but he should go back to where he came from. This is not only a case of effectively banishment, but as Claire mentioned, it is also a case of double punishment by telling Deepan and telling others in Deepan's situation that if you commit a criminal offense, you're less deserving of having that tie to Canada and the right to live in this country. And it's a slippery slope. We know with the recent amendments to the Citizenship Act, Bill C-24, the Conservative government is making it easier to loosen those ties that people have to Canada as dual nationals. In Deepan's case, of course, he is a uninational. He only is a Canadian citizen. To give you the brief update on his case, and I'd like to thank all of those of you who are part of the support committee and continue to advocate for Deepan and for the plight of those people who are stateless. As many of you will know, in September of last year, there was a ruling of the federal court. We went before the federal court to make a pitch, to make a request saying that this is an absurd situation. Ask the federal court directly to rectify the situation because the Minister of Citizenship and Immigration basically has a closed mind to Deepan's case. He's made up his mind that because of Deepan's criminal history, he no longer belongs to Canada. That is an improper and we would argue basically a conclusion in bad faith. And we're asking the federal court to intervene directly so it would declare Deepan a citizen. We were denied by the federal court in September of last year, saying that basically it's not an imposition on Deepan. Although he doesn't have access to health care, he doesn't have access to proper work through a consistent social insurance number, and although he has precarity from day to day, because he's not going to be immediately deported, his rights under the Charter of Rights and Freedoms are not engaged, and therefore the court did not conclude that it would grant him any kind of declaratory remedy that he's seeking. The court made, in our view, serious factual and legal errors, and we have appealed that to the Federal Court of Appeal. We've perfected that appeal, and we seek to argue that sometime in late spring or summer of this year. So we're hoping that the Federal Court of Appeal will basically put an end to Deepan's plight, but also to set this absurd situation straight. There can be very easy political action by the minister to rectify this situation, and often the courts are reticent to intervene where they think it's a political matter. In this case, however, because the fundamental rights and freedoms of an individual are engaged, because the implications of being rendered stateless means that everything that we take for granted in Canada is put on hold. Everything we understand from the right to vote, a franchise, from the right to work, the right to have health care, all of that stuff is put in limbo. And so by a simple declaration by the federal court, that situation can be rectified. We believe that the political will does not exist on humanitarian grounds for the minister to do the right thing. Therefore, it's up to the courts to intercede in this case. So this case will not be won or lost necessarily before the courts, but it requires a groundswell of public support, and that's why these kind of public venues are very important. So people like you come to know what the case is about and understand that it is certainly a case about one individual, Deepan, but it's also broader than that. And the implications of this case touch all of us and touch the value of citizenship. So I urge you to support Deepan's case, and if you can, to support the federal court appeal that will be heard later this year. Thank you.
Thank you very much, Yavar. Next on the speaking panel, we have Michael Kempa, who is a professor of criminology at the University of Ottawa. Mike, take it away.
Okay. Thank you very much for having me today. I just wanted to lend one more small voice in support of Deepan's courageous and very difficult struggle to have his rights as a Canadian citizen reinstated. There are, of course, many good reasons to deny somebody citizenship, critically though, at time of application. And there's a long history in Canada, going back to the 1940s, of gradually establishing criteria by which you could choose not to grant citizenship at time of application for serious reasons. One very good reason is if you're intending to establish citizenship for reasons of convenience. So if you're not intending to reside in Canada for any meaningful period of time or to make a contribution to Canadian society, if you're intending to only travel using a passport of convenience from Canada and perhaps make use of Canadian services at home and abroad, if times should become difficult for you. These are good reasons to deny citizenship to begin with. If you in fact have hostile intent towards Canadian society, prior to the granting of citizenship, this is a good reason to deny citizenship. The critical thing being that once, of course, your citizenship is naturalized, either for the reason that you were born here or your citizenship was granted by government, that the rights and responsibilities of citizenship become inalienable, which means they cannot be taken away. Unfortunately, what the Harper Conservative government has done here, as they've done so many times in the past, is they've combined the good elements of being selective in the granting of citizenship with these bad elements. The consideration of any behaviors that come after the award of citizenship is in fact not within the legitimate power of a democratic government. And this is something that has been argued in our courts here at home and is being argued at the moment and throughout the Western democracies. This is something that most constitutional experts would say simply is not a power available to a democratic government. I think what we can say is that once immigrants, or once citizens in any form are naturalized, they become our common resource in Canada, making a contribution to our economy, to our culture, but also our common responsibility. So at that point, should behaviors become troublesome or even criminal, it remains our responsibility to work with those citizens and continue to give them, to afford them, not give them, to continue to honor their constitutional rights in this society. So what I would really like to end with saying is, it's a very scary development indeed, where behavior after the formal, essentially, solidification of your citizenship can be considered for the revocation of citizenship. It's a scary development in the sense that it creates two tiers of citizens, those who are born here and there's no controversy surrounding their status, and those who essentially have a form of permanent residence extended into citizenship. It's a wholly unacceptable matter, and we thank you very much for being here today to lend your voices to this important struggle.
Thank you so much, Mike. At this time, I'm going to pass a donation jar over to committee member Baljeet, who's going to pass it around. If anyone has any money, change, or anything they'd like to donate, we would appreciate that for the continued support and raising funds. Next on our panel, we have Daiva Stasiulis, who is a professor of sociology at Carleton University. Her research focuses on citizenship, and we're very happy to have her here. Daiva.
Thank you, Josh, and thank you to Taylor and the other organizers of this event, and for inviting me to be part of this esteemed panel. And I'd like to begin, like others, by stating how courageous I feel that Deepan is in pursuing this struggle to regain his Canadian citizenship and access to his rights, such as medical care, and how important it is for an activist community to continue to support his struggles against statelessness and rightlessness. I'm just going to pick up actually on a remark that the last panelist, Michael, had made about reasons to deny citizenship, because I think that the processes by which people are rendered without nationality and in many cases stateless are ill understood, and there are many different paths to statelessness. And some of the arguments are ethical and moral, and some of them are legal and technical. And what has been, I think, preoccupying me of late are some of the technical arguments that are being used. But I want to address the point that Michael raised about citizenship and convenience. Actually, legally, there is no prohibition against being a citizen of convenience. Ethically and politically, this was the particular label that was used when a certain group of Canadians sought assistance from their government in the 2006 war in Lebanon. And the fact that it cost the Canadian government something like $85 million was repeated over and over again, and in a way that suggested that this was not quite legitimate, because at least some portion of those people seeking assistance in fleeing from war from their government were citizens of convenience, a charge that was never actually proven and probably applied to a very small number of those people who received that assistance. However, it was a really, really significant event as far as citizenship was concerned, because it became the moment and the rationale for the Canadian government to say, we have to revisit our citizenship laws. We have to make it more difficult for people to get citizenship. We no longer can afford our lax and generous policy of dual citizenship. So let's revisit some of these issues. And that's what they've effectively done. And so what I'd like to talk about here is, first of all, the context, political and legislative context in Canada that have led to the unusual case of statelessness imposed upon Deepan. Second, I'd like to examine the particular conjuncture of processes and arguments that seek to justify the statelessness of someone in Deepan's unusual situation. And third, I'd like to provide some counter-arguments to contest those who seek to deprive Deepan of his birthright citizenship in Canada. So first the context, and with thanks to Justin in covering some of this context in terms of both a focused attack on so-called global war and terrorism, but a much, much broader attack on civil liberties of Canadians and an attack on dissidents. But what I'd like to talk about in terms of the context is the expansion of populations in Canada with precarious legal statuses and the transformation of citizenship from an inalienable right to a privilege rather than a right. So the number of people, the population of Canada with precarious legal statuses is proliferating. And here are some of the policy reasons why. Security-driven and marketized immigration and refugee policies of the Canadian government that commodify migrants, import disposable labor rather than future settlers or citizens, restrict the source countries of asylum seekers, reject legitimate refugee claims, devalue family reunification, treat marriage migrants and asylum seekers with suspicion, and all but abandon humanitarian goals within these policies. So a series of reforms to immigration, refugee, and citizenship policies by the Harper government, as well as anti-terrorist legislation such as Bill C-51, are creating two candidates. One consisting of citizen members who can enjoy an effective nationality. So a collectivity that continues to enjoy statefulness and the right to have rights, and another growing Canada consisting of lives of desperation, poor health, managed by discriminatory state policies, discretionary decisions, and often unscrupulous employers lived in the shadows, governed by legal precarity, partial, temporary, and provisional rights, and even legal non-existence. So, since 2008, the Canadian government has been waging a campaign to make citizenship harder to get and easier to lose. I won't go over all the provisions of these reforms in 2009, but in 2014 as well, the Canadian government brought in more stringent residence and language requirements to acquire citizenship and new citizenship stripping provisions targeting those who obtain citizenship by naturalization, as well as dual citizens. And many human rights advocates are exercised by the new forms of discrimination, the hierarchizing of citizenship that these reforms have introduced, levels of citizenship. We talk about first class, second class, etc. But these are all unfair and discriminatory. The federal government has been reviewing citizenship policy now with regard to birth tourism, suggesting that it may next abolish or significantly amend, qualify, use solely birthright citizenship among those born on Canadian soil in its relentless quest to erode and hierarchize Canadian citizenship. Now, many of these policy reforms are rationalized in terms of the abuse of Canadian generosity and are introduced in an environment of fear and racialized othering. Now, use solely is under attack despite the evidence that even so-called birth tourism, whereby foreign women travel to Canada to give birth here to claim automatic citizenship, and the so-called anchor babies that result, represented infinitesimal, less than 0.01% of all live births in Canada. So these citizenship gatekeeping, stripping, and weakening provisions are consistent with a policy agenda to utilize immigration, refugee, and citizenship policies to erode the inviolable character of a rights-based citizenship, to underscore its status as a privilege, controlled and denied through a shifting terrain of legal and administrative procedures by state officials. Now, as importantly, the government has introduced reforms and rules governing forcible deprivation of citizenship, governed by monitoring of continuous enactment as a good and fit citizen. So a tension exists, obviously, between the human rights to nationality and a global system that supports the institution of sovereign states, who can decide, sometimes arbitrarily, who is and who is not a good candidate for citizenship, and who is and who may not be fit to remain citizens even once they acquire this. So we're aware, of course, that because of the colonial foundations of Canadian citizenship, persons with white skin privilege and certain values are rarely challenged on the authenticity of their citizenship. In contrast, those who are othered and racialized as dangerous and undeserving through racialization processes that pick up on skin color, national origins, indigeneity, increasingly religion, through Islamophobia, undergo more intense surveillance in acquiring and retaining this so-called privilege. And I should just note that this is not just happening in Canada. It's happening in many countries in Europe, in France, UK, Netherlands, it's happening in Israel. These countries have all amended their laws to make it easier for states to revoke the citizenship of both naturalized and born citizens in the name of national security and fighting global terrorism. So I want to move on to the second part of my remarks, which is to briefly examine how it is that statelessness was not only produced in Deepan's case by state institutions, but also what arguments have been deployed to justify an acceptance of revoking or non-recognition of his nationality and his current condition of rightlessness. So Deepan's statelessness, despite 20 years of citizenship recognition in Canada, undermines a key assumption in international human rights discourse about citizenship in a democratic state, namely that it is inalienable unless an individual wishes to relinquish it. There's a big difference between voluntary relinquishment and revocation. So there are many paths to statelessness, and I understand this is what the project that Claire was referring to would like to map within Canada. Some of these paths are visited on whole collectivities of people through dissolution of states and mass denationalization campaigns. Some result from deliberate misrepresentation by individuals for whatever reasons, and some occur to hapless individuals who fall through the cracks of the respective nationality laws of their parents and the state where they are born, or through administrative procedures responding to technical reasoning and exceptional exceptions. So I would say that Deepan's journey to statelessness falls in the latter category. The way that Deepan's story is often told is that his citizenship first came under scrutiny while he did a stint in jail. Deepan's process of denationalization began arguably because he brought attention to himself through incarceration for weapons and drugs offenses under the criminal code. This led to the revocation of his citizenship status on the grounds that it was never meant to be granted in the first place because his parents enjoyed diplomatic immunity. And thus, any children born in Canada would not have access to birthright citizenship. Now, Canadian officials apparently were not worried that India also refused to recognize Deepan as a national and thus leaving him stateless. But it's reasonable to ask if Deepan was a young white man rather than brown-skinned Indo-Canadian, would his citizenship status and nationality ever have been brought into question? So much has been made officially of Deepan's criminal deeds that landed him in jail and brought him to the attention of citizenship authorities, including the statement by Alex Pavlich, press secretary with CIC, who said he should not have chosen life of crime if he didn't want to be deported from Canada. Mr. Budlakoti is being removed from Canada for, quote, serious criminality. But the revocation of a citizenship and removal order are not, and at this point cannot be based solely on his criminal convictions. As one of Deepan's lawyers pointed out, there are so many disenfranchised youth who have run into trouble with the law, and they don't lose their citizenship or their right to remain in the country. Rather, the government found a legal technicality, an exception to use solely to justify removing his citizenship, because they argued that Deepan's parents were in the employ of the Indian High Commissioner when Deepan was born, and therefore should never have received Canadian citizenship, having been born in a protected jurisdiction that enjoys diplomatic immunity. Now, under the provisions of the Citizenship Act, citizenship is granted through both jus soli and jus sanguinis. So that would be the rights of the soil and the rights of life. The Citizenship Act states that citizens are persons born in Canada through jus soli, with the sole exception of children born in Canada of diplomatic or consular officials and employees. Now, why this exception? One argument, which is made by someone named John Fear, is to prevent the creation of super citizens. Diplomats are governed by the Vienna Convention on Diplomatic Relations, which protects diplomats and their family members from any form or arrest or detention. Now, the argument is that without this exception, in the Canadian Citizenship Act, children of diplomats and their employees born in Canada would enjoy greater rights than average Canadian citizens because they could access all the benefits of Canadian citizenship, but also invoke diplomatic immunity if they break the law. In other words, we do not want to create, quote, super citizens, and these would be super citizens. At issue in Deepan's citizenship deprivation is whether or not his parents worked for the Indian High Commission at the time of his birth. The government contends that the documents he received proving that he had Canadian nationality, his birth certificate and the two passports, were issued in error. Whoops! So normally a Canadian birth certificate would be proof of Canadian citizenship. Hospitals regularly issue birth certificates of babies without checking whether their parents are or work for foreign diplomats. In September 2015, the federal court chose to discount the evidence put forward by Deepan's lawyers, supported by an affidavit from the then presiding High Commissioner, that his parents had indeed left the High Commission prior to his birth. The court argued that this affidavit suffered from possible faulty memory pertaining to events that transpired 25 years ago. But I'd like in my remaining minutes to offer alternative arguments to contest the government's position or presumption that underlies the exception to birthright citizenship among diplomatic staff about why Deepan should be deprived of his citizenship, on the argument namely that to grant it would possibly render him a super citizen. Clearly, Deepan did not enjoy diplomatic immunity, never invoked it when he was charged with criminal offenses. Deepan was born in Ottawa, possessed an Ontario birth certificate, and believed for some 20 years, in good faith, that he was a Canadian citizen, a belief supported by the Canadian state, which issued him 2 Canadian passports. Believing and having been led to believe by the Canadian government that he was a Canadian citizen, Deepan served out his sentence in a Canadian jail. Critical criminologists will argue that Deepan should not have to undergo double punishment and suffer the punitive impact of citizenship deprivation and statelessness. He's already served his time. But there is another double punishment that the federal government has reserved for Deepan in the non-recognition of his birthright Canadian citizenship. Citizenship is more than a legal bond. It's an important legal bond between the state and individual. And that legal status is fundamental to the enjoyment of even basic human rights. Without it, you don't get certain documents. And these documents are important to access other documents and to access rights. We live in a documentary state. But it is also the lived experience of that bond, or what the International Court of Justice in the Ottawa case referred to as the social fact of attachment, that is important in citizenship. In this sense, citizenship is not replaceable one with the other, as the lived experience of citizenship pertains to particular attachments, to particular states, territories, peoples, cultures, networks, landscapes, even snow, and baskets of social benefits, which makes a relationship between a state and a citizen as singular and unique. The courts at the moment are saying, we don't know for sure whether Deepan is stateless. Perhaps there is some other state that will claim him or take him. That's ridiculous. Citizenship is not about any state taking someone or claiming them. It is about a very particular and unique attachment to a particular state and all of the lived experiences, all of the social relationships, all of the rights that pertain to that particular citizenship. Deepan's life since birth has been a product of Canadian conditions his entire life. This includes his troubled Canadian childhood, his forays into the wrong side of the law, as well as his efforts to rehabilitate himself through education, through labor, and through this campaign to regain his right citizenship. Why have not his strong claims to place and protection by the state not been reflected in the adjudication of his citizenship? So this leads to a question of the assumed punitive step of citizenship, revocation, exile. But exile to where? So this is what I find so deeply troubling about the federal court decision of Judge Delisle in September 2014, in upholding the revocation of Deepan's citizenship. On the technicality of the contested fact, the date when his parents ceased being diplomatic staff in relation to the date of Deepan's birth. This decision relies on only the thinnest notion of citizenship, one that fails to acknowledge that citizenship involves embeddedness of individuals in a network of relationship that includes both the public sphere and civil society in a particular country or place of habitual residence and over a period of time. There's no recognition that citizenship for Deepan since birth involved 20 years of lived experience and social and affective ties, and the disproportionate harm that is rendered to him by depriving him not just of any citizenship, but of this specific citizenship. The federal court skirts the issue that the home country of his parents will not recognize him by arguing that it's reasonable to assume that they might. This is a clear and discriminatory attack on naturalized citizens and their children who are assumed to have access to multiple citizenships, even when this is clearly not the case. So even if India provided him with some legal recognition, which they have not, Deepan has no social or affective ties with any country other than Canada. So by revoking Deepan's citizenship, this Canadian government does inflict intrinsically grave harm that is separate from, though exacerbated by, the harm of statelessness. Citizenship revocation schemes mean that citizenship is now emerging as an enhanced form of conditional permanent residence. Revocable through the exercise of executive discretion. This diminishes citizenship such that on the continuum from absolute security to absolute precarity, no one is absolutely secure. And this is why we need to care about what happens to Deepan and what and how the state is doing to Deepan, creating his statelessness and in the process of undermining the ability of citizenship. I apologize for going on a bit long. Working out, I think.
I got it. Thank you. Thank you very much. I just want to finish off with some closing comments, and then we can open up a Q&A. My name is Joshua Warushka. I'm a core member of the Justice for Deepan Support Committee. I'd just like to thank Justin, Claire, Yavar, Michael, and Daiva for their comments on Deepan's case, their continued support, and as a committee, we sincerely appreciate it. I would also like to thank the organizers of this event. Without continued support in and around the Ottawa community, it would be impossible to raise awareness and ultimately continue the struggle to restore Deepan citizenship here in Canada. So let's give a round of applause again to the panelists, the organizers, and everyone who filmed and produced Illegalization. I just want to give some background. The Justice for Deepan Support Committee was established in July of 2013 in order to support Deepan in his quest to have his citizenship restored. In that time since I joined the committee in 2014, we've held community events such as this one. We've taken the case to the federal court. We've worked in collaboration with the Canadian Civil Liberties Association to file an individual complaint with the United Nations regarding Canada's breach of international law, including the International Covenant on Civil and Political Rights, as well as the 1964 Convention on the Reduction of Statelessness, to which Canada is both signatory to. The committee and our partners have raised thousands of dollars in funding to support Deepan's continuing legal proceedings, as well as other costs associated with being stateless in Canada, including an inability to access health care. Prior to joining the committee, I had first heard about Deepan's case while completing my undergrad degree. I was floored to find out that an individual who had been born in Canada, had been living in Canada for almost 20 years, had his citizenship revoked, and was being threatened with deportation to India, a country that he had not lived in and frankly did not have citizenship to. It was clear that not only was Deepan undeportable, but he was now a stateless individual in Canada, something that should not exist in this country. At the time, I was working with the Canadian Civil Liberties Association as an intern and organized an event entitled Statelessness, Citizenship, and Belonging in the Case of Deepan Budlakoti. Since the event, I've joined the committee as a core member and continue to assist my friend in his quest to restore his citizenship, to live a normal life, just like any other reasonable person in the same situation would not only ask but demand. The whole process is quite surreal, and for the most part, the actions taken against Deepan on behalf of Canada are unwarranted, arbitrary, and absolutely unnecessary. Canada not only has an obligation not to participate in the proliferation of statelessness, but also to not actively produce it. While Canada has asserted that Deepan is prematurely stateless, as Daiva has alluded to, and all my research on statelessness and all the conversations I've had with civil society organizations, there is no such thing as prematurely stateless. You either are or you're not. There is no window in which you must determine if you don't have a nationality. If the government on the left and if the government on the right both say that you don't belong in their country and you cannot be deported and you continue to live a life in Canada under detention conditions as a stateless person, it is absolutely inconceivable to assert that this is all just a little premature. The committee has been fortunate to raise and garner the support of several civil society organizations that have been generous in their continued effort to assist and support Deepan. It goes without saying that without this support, we would not be here today with these lovely individuals and with everyone here who is listening. I would like to give acknowledgement to the extensive list of supporters, including the National Union of Public and General Employees, the National Union of Public Service Alliance of Canada, the Ontario Federation of Labour, the Canadian Association of Refugee Lawyers, the Council of Canadians, the United Food and Commercial Workers Association of Canada, the Canadian Union of Postal Workers, the Ontario Civil Liberties Association, Amnesty International Canada, the British Columbia Civil Liberties Association, the Canadian Civil Liberties Association, OPIRG Carleton, as well as OPIRG Ottawa U, as well as York's OPIRG, UFT, Kingston, Waterloo, Halifax, Windsor, as well as the Mosaic Immigrant Society, and of course the Criminalization and Punishment Education Project. Furthermore, we have received support from the members of the New Democratic Party who were integral in assisting us in processing legal documents that were pertinent to Deepan's ability to seek work in Canada. Furthermore, Elizabeth May, the leader of the Green Party of Canada, has supported us and issued a statement on behalf of herself and the party. Without the support of these organizations across Canada, we would not be able to sustain the campaign and maintain the continued struggle to restore Deepan's citizenship and put an end to these unjust and racist immigration policies that throw away undesirable people when the government decides that they no longer belong here. So I would like, again, to thank everyone who has been involved. The committee and the legal team, including Yavar and many others, continue to harness this support to raise awareness and continue to fight to restore his citizenship. As Yavar alluded, we will be going to the federal court this year to appeal the decision rendered by Justice Phelan in which he dismissed Deepan's claim and left him in a legal limbo without access to the basic rights that he enjoyed for over 2 decades. In February of 2015, we also went to the Health Services Appeal and Review Board, in which we argued Deepan's charter rights had been violated as a result of him being denied access to healthcare in Ontario. Without healthcare, Deepan cannot access basic services that we all enjoy. We were successful, although, in December of 2014 in raising a good $1,000 to purchase Deepan healthcare in a campaign that we called Health for All. We were able to get the money, raise the support, and Deepan now has healthcare for 1 year. The only problem is we have to do this every single year. The committee has been active in organizing and putting in events. In October 2014, we also raised thousands of dollars in an event that we titled An Evening with Barbara Jackman, who is Canadian. It goes without saying that Deepan's legal costs have a real impact. This is not just an abstract theoretical concept that sits in your textbooks. Deepan's legal costs are in excess of $60,000. He has no access to health care, and he has very little access to work. While the work permit does exist, he also has a criminal record. So as you can see, he's both marginalized on many levels and vulnerable. We also have been able to get support from the media. We've been featured on global television 16 by 9, and we have received considerable media attention in Rabble, the Ottawa Citizen, Al Jazeera News, the National Post, the Globe and Mail, the Toronto Star, CTV News, and Huffington Post, among others. Even with all the continued support from these organizations and individual supporters like yourself, Deepan remains stateless on detention conditions in Canada. That is the reality he lives every day. We must not stop here. We must continue the fight to restore Deepan's citizenship, say no to double punishment, and reject these unjust policies which claim that we can simply eject undesirable people when the minister says so. Deepan is a Canadian. He always has been, and he always will be. Deepan is a member of our community, and Deepan is my friend. I stand with him as he struggles to survive and fight for his right to remain with his family and with his friends in the only country he has ever known and the only country he has ever called home. I am here to say that Deepan is a human being who not only deserves but demands the right to have rights. Deepan is not an error. He is a Canadian who belongs in Canada with his friends and his family, and I call on you today to continue your support by raising awareness and demanding that he be immediately released from these unjust conditions through restoring his citizenship and ending this long legal nightmare which has wreaked havoc on his life. On Friday, April 24th, we will be holding a Justice for Deepan benefit concert at Zaphod's in the Byward Market in order to raise awareness and raise funds to sustain the campaign. The event starts at 8 p.m. and features some bands. Tickets are $10, and you can make an impact by purchasing a ticket and supporting Deepan in his quest to restore his citizenship. If you cannot attend the event, you can still support our campaign by visiting justicefordeepan.org and going to the section, What Can You Do?, where I encourage each and every one of you in this room who hasn't already to sign a statement, to write a support letter, to visit our Justice for Deepan shopping channel and purchase merchandise to show your support in the community, and more importantly, we ask that you please donate to the campaign by becoming a monthly sustainer. Monthly sustainers give the campaign the ability to sustain itself and move forward in rejecting double punishment. In closing, I want to thank everyone else again for this event and all the support. I would also like to thank the panelists, the organizers, and on behalf of the Justice for Deepan Support Committee, thank you. We'll just open it up for a Q&A. Does anyone here have any questions for any of the panelists? I know that you were taking some notes, so I don't know if you have any questions or things that you would like to clarify. Or no? Okay. And does anyone on the panel have anything to say with regards to the panelists? Any comments or last words? No? All right. Thank you very much, everyone. Have a great day.
maybe just one last comment to thank Josh for quarterbacking this and making this an event on it informative afternoon. Thank you, Josh.
I'd like to just also thank all the students in my class that were involved in organizing this. Very good. Thank you very much for doing this, and thank you for having an event like this that has drawn people in. You did a really good job. Thank